So what is IP due diligence? Well, it's the thorough, systematic review of the IP that's owned and used by an entity involved in a transaction. So in order to determine the value of the IP being acquired or financed and any risks that may be associated with that IP, searches are oftentimes needed. And these searches are usually launched due to the same kinds of transactions that we went over just a few slides ago, and they're often done at the same time. So when you're conducting the searches for UCCs and liens and litigation, many are now tacking on the intellectual property at the same time. So that is now becoming more of a typical transactional due diligence package. However, the IP due diligence searches don't have to wait for some event to take place, an acquisition or lending activities. Organizations don't need to wait for that because it's important to conduct IP due diligence on itself, on the entity. It is a best practice for organizations to check the IP assets that exist in the public record at the USPTO or the U.S. Copyright Office and conduct searches on their own IP portfolio to remedy any defects and gaps that might exist outside of the pressure of a time-sensitive transaction. And that's akin to, for example, if I'm going to purchase a home. I've made the decision I want to move into a new neighborhood. Before I start the process of searching for a home, I need to check my credit rating and make sure that everything is in line with the three major credit reporting agencies. I know what my credit score is, but having not embarked on any sort of major loan or anything, I don't really know what the details of the credit reports say. And it's possible that there's incorrect information there that needs to be cleaned up, or maybe there's something else that's there from years ago that I have neglected to deal with or forgot about. So by requesting and reviewing my own credit reports, I can clean up anything that shouldn't be there so that I can get the best possible loan and the best possible house. If I'm scrambling because I didn't unearth that in advance of the deal, that could affect the type of loan I get, and it may not be a desirable loan at all. So it's similar to that if you're doing IP due diligence on yourself. It's cleaning things up before you get into the middle of a transaction. So what considerations do come into play? Well, while it would be easy to say that every type of search should be conducted on every type of deal, that's not realistic, it's not accurate, and it's not what's recommended. There are differing factors that come into play in determining what you're going to search and where you're going to search. And oftentimes it comes down to what's the size of the deal? What about the deal budget? How much IP is owned by the seller? Is the IP central to the deal? It may not be. However, if it is central to the deal, then most definitely something that should be considered is intellectual property due diligence. What are the business plans the buyer has for the IP in the future? Are they intending to expand into new markets that they weren't in before? If yes, then it would be important to conduct IP due diligence. So in addition to that, giving some thought to, is the IP registered outside of the U.S.? Are there any foreign licenses pertaining to the IP? Because our focus here today is searching in the states and at the federal level, but it may be necessary to expand the scope of the search beyond the United States and looking at other countries for IP interests. So some additional challenges that we've learned about as we've talked to different folks throughout who conduct IP due diligence are that, well, the security interests that are found in filing offices that they're not familiar with. So searching the USPTO and U.S. Copyright Office is often not an office that many searchers are familiar with, and so they're not comfortable making those searches. And then parties who do conduct searches, they're not really sure what they're looking for when they're conducting a search or what they're looking at when they actually find something. Further, deal budgets have not often been adjusted to include intellectual property due diligence. Somehow it has fallen off of the list of considerations, or because it was never there, it's an afterthought and has to be dealt with separately later. And parties involved in the due diligence process often just assume or believe that the IP due diligence is handled by another department, say the IP department within a law firm, or maybe that it's just not material to the deal or it's just handled by someone else because it's not on the due diligence checklist for them to follow through on. Frequently, IP experts are provided with a list of IP properties late in the process. So whether you're the IP expert or just somebody who's responsible for the deal in general, you're handed a list, this is the IP that's owned, and that's what you're going off of. And it's up to you to determine if there's any issues that need to be resolved, or if there are issues, that often leads to sort of that last-minute fire drill or shortcuts before the closing because it didn't get the same consideration that the other due diligence pieces of the puzzle did get, the liens, the litigation, the bankruptcy. And some IP due diligence related information doesn't even exist on the public record. So for example, licensing arrangements may not be included in the public record. So that requires asking questions, going to others to get information because it's not something that can be uncovered through a due diligence search. So what is the distinct value and purpose of conducting intellectual property due diligence? Well, it seeks to answer several questions which impact the value of the assets being acquired and to determine what level of risk management is needed. So if you're conducting these searches for a client, you're wanting to make sure that they're getting everything they thought they were going to be getting in order to take full advantage of the transaction. Are they getting everything they think they're paying for? And are they going to run into any problems later on which might devalue the purchase, the investment, or the license? What work may be necessary before the close of the deal to make sure these challenging and costly fixes are not required later? So it's important to provide this information on a moving forward basis to minimize any potential risks. On the flip side, if the entity is trying to maximize its value before going out and being acquired, they can demand top dollar or negotiate that because everything isn't in order and the IP that they're providing as an asset is free and clear of encumbrances. So it works on both sides depending on the side that you're on. So what are you looking for? What are you looking to uncover during the intellectual property due diligence process? Well, you're looking to determine whether there are any liens or encumbrances or claims on the IP. So it would be similar to looking for statutory liens or UCC liens that maybe are filed against real property. You're looking to see what's out there, and you're doing that to identify or confirm the IP in the transaction, even if it has been provided by another party, which is not unusual. Usually a list of IP is provided saying this is what we have the rights to, and now it's up to you to confirm that that in fact is correct and that everything is in line as it has been provided. You're looking to confirm the ownership of the IP properties and their chain of title, even if it's already been provided by the other party. Are there any existing licensing agreements relating to the IP, which may or may not be evident in the public record as we've mentioned before, so this requires some additional searching. And are there any third-party challenges to the IP? There could be something going on that needs to be brought forth, and so uncovering any of those challenges against the IP becomes very important.